Good evening. This is John Milburn for Laws 13010 Evidence and Proof. We're into week 12, so we're now just over a week before the examination. The exam itself is not difficult. If you follow the previous exams, you'll have a good idea of what to expect. And there's no reason why you can't prepare a lot of the advances in anticipation. So please do that. Have a good outline ready to go. If you have any questions about the exam, let me know. But really, it's quite straightforward. All right, I will cover a few basic things tonight that are new. Do you have any questions about the exam or the course generally before we do that? No? All right. It occurred to me that I should make a few comments about the process of drawing inferences. So an inference is what you want the court to draw in a favourable position to your version of the facts. When I say a court, that could be the jury or it could be a magistrate, depending on the jurisdiction they're in. And when it comes to drawing inferences and reaching conclusions, there is, of course, a difference between the criminal law and the civil law. So the difference particularly is evident in circumstances where the respondent or defendant in a civil proceeding does not give or call evidence compared to the situation where that occurs in a criminal proceedings. And the main difference, why it's different, is of course that in our criminal law, a defendant, an accused, is under no obligation to make any statement in relation to anything that can be said. So if the defendant in criminal proceedings chooses not to say something which might otherwise assist the person who's trying to work out guilt or innocence, that's treated fundamentally differently than is the case in civil proceedings. So if someone doesn't call evidence in a civil matter that you think is really obvious that evidence should be called to assist in the process of unravelling the problem, as the opponent, what's the case that immediately comes to mind to say you have breached the rule in something by failing to call this evidence or give this evidence that really would be expected of you to assist? I know there's only a couple of you online, so it's mean to ask questions. I think Catherine's onto it. No? All right.
Sorry.
Dana? Think Jones and Dunkel. So there's the rule in Jones and Dunkel that basically says that if someone chooses not to call evidence that might have been expected to be called, then it's open to the court to make an inference about that against the party that chose not to bring that evidence before the court. But that rule generally doesn't apply to criminal proceedings. Look, there is a case that you probably should look at and have up your sleeve. It's called RPS. That's the initials, RPS, against the Queen. It's 2000, High Court of Australia 3, or another citation, 2000, 199, CLRs 620. And the High Court said in that case about this question of whether a person should be giving evidence or might be called upon or to give evidence, or if there's an adverse inference that they chose not to give or call evidence. In criminal proceedings, the High Court said, not only is an accused person not bound to give evidence, it's for the prosecution to prove its case beyond reasonable doubt. And the observations by the court, the High Court, in Jones and Dunkel, must not be applied in criminal cases without taking those considerations into account. And that makes a lot of sense, doesn't it? So what the court is saying is, hey, if the Crown brings the charges, it's up to them to prove it beyond reasonable doubt. If they don't have enough on their case to prove that the defendant is guilty beyond reasonable doubt, then that's the end of the matter. Why do we need to hear from the accused person? And why should there be an inference against the accused person in circumstances where they simply exercise their right to remain silent? Now, in Mahmood against the state of Western Australia, that's MAHMOOD against the state of Western Australia, another High Court decision, I'll give you two citations again. That's 2008 HCA 1 or 2008 232 CLR 397. The High Court said about a witness not being called. The High Court said, where a witness for defence was not called, the question is not whether the jury may properly reach conclusions about issues of fact, but whether, in the circumstances, they should entertain a reasonable doubt about the guilt of the accused. So, in that case, it was about civil penalty proceedings. And what it does not mean, but that does not mean that the rule in Jones and Dunkel automatically applies to civil proceedings, which are civil penalty proceedings, which attract the same privilege as criminal proceedings. So I guess what I'm really asking you to do there is think about that question about failing to give evidence or call evidence in the context of civil proceedings, so think Jones and Dunkel, or criminal proceedings, and have that quote from the High Court up your sleeve, but then the hybrid situation, which is dealing with civil proceedings, but there is a civil penalty imposed, and think about Mahmood against the state of Western Australia. Now, when it comes to a defendant not giving or calling evidence, the next thing that might come to your mind in relation to criminal proceedings is the rule in Weissensteiner against the Queen. And in Weissensteiner, which is 1993 High Court of Australia 65 or 1993 178 CLR 217, the court dealt with the situation in a criminal law context of someone not giving evidence. And that case is authority for this general proposition, that it is easier for the tribunal of fact to draw inferences about circumstantial evidence against a party who must be able to give evidence on a topic but chooses not to do so. So a version of Jones and Dunkel, if you like, in the context of what was said in Weissensteiner, may still be relevant in criminal proceedings, but not always. And the case that you need to consider to offset that is as a party. All right. And just finally, when I've been talking about these hybrid situations of civil and criminal, just bear in mind a very useful thing to keep up your sleeve whenever you're talking about the standard of proof in civil proceedings is the thing called the test in Brigginshaw and Brigginshaw. You've probably seen that already. It's really handy to have up your sleeve. So the actual citation for Brigginshaw and Brigginshaw is 1938 HCA 34 at 34 or 1938 60 CLR 336. And that case is one that comes to mind where we're talking about applying the civil standard of proof, but where we think about the introduction of a sliding scale, the sliding scale meaning where more extensive proof may be required. And that case discussed the issue of the gravity of the allegations before the court may lead the court to conclude that the plaintiff must establish proof to a high degree of satisfaction. The reference to a high degree of satisfaction doesn't change the burden of proof. It's still on the balance of probabilities, the civil test. But there must be a good quantity of proof, the quality of the proof must be there so that the court is satisfied to a high degree of satisfaction, and they're not having to guess on very limited information. If it's a really important decision and there are grave consequences, even though the court has to decide on the balance of probabilities, the court is entitled to say, no, you've got to give us more and better proof than just that little snippet of proof. That's not enough for us to make a proper determination. We want to see much more extensive, much better quality proof, proof to a highest degree of satisfaction before we're willing to say on the balance of probabilities one way or the other. So I hope that you understand how Brigginshaw, it's like a scale for probative value. I like that, Diana. That's a good way of putting it. And there is a statutory provision in the Federal Evidence Act, the Uniform Evidence Act. Have a look at section 140. Okay. So that's all the new stuff I wanted to talk about tonight. As far as the exam's concerned, it's pretty straightforward. I think from memory it's 2 hours, correct me if I'm wrong. I think it's the 13th of June, correct me if I'm wrong. But the point I guess I want to make is, if you're watching this video later, please make sure that you go to, I think it's called My Centre on the CQU website, for your individual personalised information about the exam. Now, I don't know much about that because I don't get involved in that process. Just to explain, I write the exam ages out, and I mark the exam and upload the results, or have those results uploaded, but I don't get involved at all in the logistics of the exam. I don't nominate the time, the place. I nominate the duration, but that's about the extent of it. Okay, so make sure that you're aware of where the exam is. Make sure you get there a bit early so you're ready and prepared to go and have all those basics right. One thing I have said tonight is there's no reason why you can't have many of your answers prepared in advance, ready to go. No electronic devices, but I'm sure you're all aware of that. All right, are there any questions about the exam, or are we all good to go? Yes, Diana?
Hey, John, I got a question. It's in regards to the authorities. When we have to do the citation for the authorities in our response, what would be the best way to do it?
In an exam situation, when you're in writing, I'm glad you asked that question. I would not attempt to try to footnote reference, and I wouldn't expect you to footnote reference. So you can use Harvard-style referencing, which is if you cite an authority, a proposition, or something from a statute, for example, then immediately following it, just put in brackets Section 7 Trusts Act. And you can do a shorthand version as well. So if you're referring to, a well-known case, Jones and Dunkel, I don't necessarily need the full citation. You can maybe put in the citation the first time, but after that Jones and Dunkel, or even just Jones and Dunkel, that's okay. I understand that in an exam you'll be under pressure, so don't attempt to footnote reference. Does that help answer your question, Dana?
Thank you, John. Yes.
Okay, thank you. All right. And I have put some guidelines for how to deal with examination questions on Moodle. So please have a look at that and refresh your memory. Okay. Other than that, please have your say. I'm sure you've already done that, but I still need a lot more answers. I need 50%. So please, if you haven't responded, please do so. I'd appreciate that. Okay, unless there's any questions or comments, we're just about done for tonight, for the course. Any questions?
Sorry,
comments?
I got another question, sorry.
That's good.
It's in regards to, again, the authorities. What would you like us to cite? For example, we got a very important case for the question, but we also got the legislation. What would be the best? Maybe cite both of them, or or just the cases or the legislation?
Look, I'd go with both. But again, that's another really good question, because it prompts me to remind you that you don't need to cite a string of cases as authority for a proposition. So if you've got a leading case or a statute that is directly on the point, then if you're comfortable just leave one of those, that's fine. If you believe that both the case and the statute are important for the authority, put them both. But if you're talking about a general proposition of evidence, and you know that that proposition was considered and applied in 10 cases, you're not going to get any value by adding, cases 2 to 10. So just give me the lead case, or a lead case will be sufficient. You don't have to give all the cases. Again, I hope that answers your question, Dana.
Yeah, thank you very much, Andy.
Thank you. All right. Just see the check facility. Yep, probative scale. Okay, well, thank you very much for attending. Nice to see that you've been here most weeks, and I appreciate that. Good luck in the examination. If you have any questions, please ask through UCrew, and we can all share in the responses. So I'll end the meeting now. That's the end of the course. Good luck in the examination. I'm sure you'll do very well. And I'll get the results, I think. I owe you some results, don't I, for one of the assessments, or am I mistaken? Yes? Results, I think, will be out on Sunday. Okay, great. All right, we'll do that. Thanks very much. All the best. See you then.
Bye.